Hi, I'm Lauren Kreamer and I am a barrister at Radcliffe Chambers with a broad commercial chancery practice. I started my pupillage in October 2016, and that's just about recently enough that I can still recall what it was like to be a pupil and also how steep of a learning curve pupillage was, which of course makes it an extremely rewarding and intellectually satisfying time because you're learning a huge amount in a short space of time. But it also means that there is a lot to learn. I've been asked to talk about when you first start pupillage, what guidance there is, if any, on how to draft complex orders and the kinds of things that you have to draft arising out of any hearings you might do early on in your practice. Part of what makes the structure of pupillage at Radcliffe so strong, in my view, is the split between your non-practicing and your practicing 6 months. So in the first 6 months of pupillage, our pupils learn from their supervisors and from other members of chambers, both by going along to hearings or at the moment signing on to remote hearings, and by looking at the work that other barristers in chambers do. So that means that by the time our pupils start their practicing second 6 months, they've witnessed and experienced a lot of different types of cases and hearings. And in my experience, that leaves you very well equipped to start taking on some of your own work. Having that being said, and having witnessed all of those different things in your first 6 months, it's inevitable that you will come across things when you start practice that you haven't seen or perhaps even heard of before. The first place to go, as you might expect, is to your pupil supervisor or to other members of chambers. So at Radcliffe, the most junior members of chambers in particular often ask each other questions and bounce ideas off of each other. It's almost always the case that somebody has come across the issue you're unsure about and will be able to help you out. The idea of having a supervisor isn't only for you to see their work, although that's a major part of it, but also in order that you have a first port of call when you're unsure about areas of your own practice when you start taking on your own cases. And that continues to apply once you've become a tenant. So I certainly still turn to my former supervisors for advice and guidance. And I know that some of them do similarly with their own pupil supervisors and have done the same thing throughout their careers. You will almost always have to go no further than that because other barristers are always keen to help out, whether it's members of a similar call to them, junior members of chambers, but more particularly pupils. If you're still unsure, you'll often find templates and examples online. So Chambers subscribes to lots of precedents and forms to which you'll have access from when you start your pupillage. And those contain standard form orders for various types of claims and applications, which are a very helpful starting point. Alternatively, a way of double checking that your order covers everything that it needs to. So it's something of a safety blanket. You can also always check in, and sometimes you'll need to check in with your instructing solicitor. So if they've been at the hearing, they'll have a detailed note of what was said, and they'll be able to confirm exactly what the judge ordered. Your own note will, of course, do the same, but sometimes where things are a bit more complicated, it's always very helpful to be able to double check the wording if need be. Also, if costs orders are being made and quick maths is being done at the hearing, certainly if you're as hopeless at maths as I am, it's always helpful to have somebody who's double checked that side of things too. The more general advice is that you just need to give it a go. You will always have templates from earlier cases you've been involved in or worked with your pupil supervisors, or from those online templates that I mentioned. But most importantly, you'll have been at the hearing at which the order was made. So you'll know the orders that the judge made, and it's just a question of getting them down on paper. There are often discussions after you've drafted an order between counsel for the various parties about the content of that order. So the likelihood is that anything that needs adding or removing is going to be picked up and worked out at that stage. And there's always, of course, a final review of the contents, which is the judge. Judges always review and approve orders that are sent through to them. So you can be pretty sure that if there's anything that should or shouldn't be there, they'll let you know.